Good afternoon, everyone. Welcome to the regularly scheduled Ways and Means Committee meeting today for March 16th, joined by Council Members Bender, Glidden, Johnson, and Palmisano, and we're a quorum of the committee. We have 18 items on our agenda today. The first 17 are consent items. So I'm just going to read through those real quickly and see if we can have any comments or questions on those items before proceeding. The first item is a series of 5 legal settlements. Item number 2 is execution of a 2-year contract with Domestic Abuse Project for hotline services. Item number 3 is from the City Coordinator's Office. This relates to the Creative City Challenge Art Competition. Excuse me. Item number 4 is at the Convention Center. This is the Hall A concession stand remodeling project. Item number 5 is from Information Technology Department. This is for the Enterprise Resource Planning Program, increasing a contract with Sierra Cedar, Inc. for those projects. The Internal Audit Department brings forward execution of a contract with Backbone Consulting for audit outsourcing. Item number 7 is the Healthy Living Grant. This is referred from the Health, Environment, and Community Engagement Committee. This executes a contract with the Minnesota Department of Health to accept an estimated revenue of $2.9 million to implement community and clinic-based strategies to prevent obesity, diabetes, heart disease, and stroke. Number 8 is the Maternal and Child Home Visiting Services Grant. This is a contract with Minnesota Department of Health. Item number 9 is from our Public Safety and Civil Rights and Emergency Preparedness Committee. This is for accepting a proposal from Hennepin Technical College for police training services for a cadet recruit class. Item number 10 is for fraud detail overtime reimbursement. This is a contract with Minnesota Department of Commerce. Item number 11 comes from Transportation and Public Works Committees. There's a number of items that do. This relates to a street resurfacing project up, 9th Street South, 11th Street North, South, 12th Street on North and South, and 7th Avenue North street resurfacing projects. Item number 12 is the 26th Avenue North street renovation project. Item number 13 is a 2015 Northern Lights Express membership fees. This is, item number 14 is for transfer station operation services. This is authorizing negotiation and execution of an amendment to the contract with Waste Management. Item number 15 is the Skyway Agreement. This is a second amendment to the agreement for Skyway construction, financing, management, and maintenance, and easements. Item number 16 is authorizing negotiation and execution of agreement with Minnesota Board of Water and Soil Resources. This is accepting a grant to be used at Lake Nokomis area private stormwater management practices. And item number 17 are a series of low bids for various construction-related projects, A, B, C, D, E activities. And those are the 17 items on our consent agenda. If there's any questions or comments, happy to have those. Councilmember Johnson.
Thank you, Mr. Chair. I just wanted to make a comment on item number 7, the Healthy Living Grant. Just wanted to acknowledge how sizable the grant is, $2.89 million over 4 years to work on combating obesity, diabetes, heart disease, and stroke, which are some of the leading causes of death. And one of the remarkable things is when choosing which cities and which states ultimately receive the funding, the federal government looked at which populations are healthier, which ones are making waves and innovating in terms of preventative services and programs. So it's really an acknowledgement of the great work that's going on both within our city and within our state around prevention of these diseases, that we would be chosen to continue that effort in order to lead by example for other states and for the country as a whole. So I just want to acknowledge and thank our staff for this work, and I look forward to the results to come.
Okay. Thank you very much for that. Councilmember Palmisano.
Thank you, Mr. Chair. I just wanted to mention that in regards to number 6, the audit outsourcing project, this is about executing a contract with Backbone Consulting, and I know that our audit department is here, and they're very excited about this. It's been a long road. I'm grateful for the work that they've done in looking to this as selecting a vendor, and I'm looking forward to the work that they can get done this year.
Good. Thank you very much for that. Okay, any other questions, comments on those 17 items? Not seeing any. All those in favor of the consent agenda, please say aye. Aye. And opposed, and those items carry. So thank you very much, staff, for your work on that. Our item on our discussion agenda today is the CenturyLink cable franchise application. There's a series of 3 recommendations coming from staff. So we'll begin with the cable officer's report. Mr. Lively, are you first up on this?
Yes, I am. Chair Quincy, members of the committee, thank you. I'm Matt Lively, Interim Director in the Communications Department. As you know, in January, the city received a cable franchise application from CenturyLink, and following a public hearing that we had last month, today we're returning to committee with a report and some recommended next steps. Mike Bradley will walk us through the report and recommendations in just a minute. Excuse me. As you know, Mike has been the city's outside counsel on cable issues for a number of years. Peter Ginder in the city attorney's office has also worked closely on this and is available for questions as well. Today we're asking for 3 things from the committee, just briefly. First, we ask that you receive and file our report on the CenturyLink cable franchise application. And as next steps, we also ask that you direct staff to engage in negotiations with CenturyLink regarding a cable franchise, and that you give notice of intent to introduce a cable franchise ordinance. To be clear, these actions would not grant a franchise at this point. Any franchise agreement that's negotiated through this process will be brought back to City Council after an additional public hearing. At that point, the City Council would decide whether to grant a franchise. To get us started today, I'd like to introduce Mike Bradley.
Thank you, Mr. Bradley.
Good afternoon, council members. Again, it's good to be in front of you. Again, my name is Mike Bradley. I'm with the law firm of Bradley, Hagan, and Gullickson, and I represent the city as outside counsel on cable franchising issues. Before you is the cable officer report that I worked with Matt Lively and Peter Ginder on. We are recommending additional action being taken on the franchise application, namely negotiating a cable franchise with CenturyLink. Like Matt said, we are not, any action that you're taking today is not approving a cable franchise with CenturyLink at this time. We wanted to take the opportunity today to walk you through the cable officer report today for your benefit and the public's benefit. And we'll get started. There's 12 sections in this report. The first section is the CenturyLink application and public record. That's it describes the process that we followed to date with the CenturyLink application and identifies the documents that are of the public record. Section 2 is a statement on the impact of competition on consumers and challenges to the new entrant. As you probably know, the FCC is the federal agency with is the expert agency in the country on communications issues, and they have made specific findings in an order called the 621 order relating to how competition affects consumers and how it affects new entrants. One of the findings that the FCC made was that competition benefits consumers by driving prices down and improving the quality of service offerings, while the impact on a new entrant when they're entering into a new market like the city of Minneapolis is that unlike the incumbent cable operator, new companies do not have the promise of revenues from video services to offset the costs of their deployment in cities. Section 3 relates to identifying who the incumbent cable operator is, and of course it's Comcast. And Comcast, through its predecessors and interests, have held a franchise here in the city since 1979. In 1982, Comcast's predecessors began construction of the cable system in the city, and in 1986, they completed construction in the city. Interestingly, in 1986, Comcast's predecessor claimed to have a cash shortfall substantially in excess of prior projections and requested and received from the city relief from certain franchise commitments in an effort to enable the company to achieve financial stability. Section 4 goes over the city's authority to franchise, and that comes from the city charter, and it comes from state law in Minnesota Statute Section 238.08. It's also important to note that a cable company cannot start providing cable services in the city until they have a cable franchise. That's under the Federal Cable Act. Section 5 lists out the applicable federal, state, and local laws relating to cable franchising. And generally that's the Federal Cable Act, the Minnesota Cable Act, your competitive franchising policies and procedures here at the local level, your city charter, and the Comcast cable franchise. Section 6 goes over the application requirements under state and local law. So Section 6A reviews the state cable franchise application requirements. Those are found in Section 238.081 of Minnesota statutes, and the cable report goes over those particular requirements. Next, in Section 6B, the report goes over what the city's application requirements are. And again, those are listed out in the report, and those are in the competitive franchising policies and procedures. Section 7 relates to federal law relating to the competitive franchising process. And it goes over the federal statute as well as the FCC's Section 621 order. So Section 7A relates to the Federal Cable Act. The Federal Cable Act requires that cities not unreasonably deny an additional cable franchise. The FCC's 621 order is identified in Section 7B. And then Sections 7C through 7G of the report go over specific findings that the FCC has made in its report and order in the 621 order. Section 7C relates to the applicability of the 621 order to state laws and local franchises. Section D relates to the impact of build-out requirements on competition and on consumers. The FCC in its 621 order concluded that in many cases build-out requirements deter competition and deny consumers a choice. Section E, 7E, identifies federal preemption of unreasonable build-out mandates, and then lists out examples of what unreasonable build-out requirements would be, as well as what reasonable build-out requirements would be. Section 7F relates to PEG, public educational governmental access provisions and institutional network provisions that are applicable to competitive entrants into the marketplace. Section 7G of the report identifies that the FCC 621 order generally preempts local level playing field requirements. Section 8 relates to state and local law concerning competitive franchising. The first state law that we identify is the state level playing field statute, which is Minnesota Statute Section 238.08, subdivision 1B. And that state law requires that no new franchise be more favorable or less burdensome in relation to three different areas. One is the areas to be served. The other is public educational and government access requirements, PEG requirements. And the third is franchise fees. Minnesota also has a 5-year build statute, which is found in Minnesota Statute Section 238.084, subdivision 1M. And in that particular statute, the the statute requires that all initial franchises have language that require construction of the cable system over a 5-year period. So the statute requires that that the cable system be constructed throughout the authorized franchise area and be substantially completed within 5 years of granting the franchise. CenturyLink is of the opinion that that particular state law is preempted by federal law as outlined in the 621 order. Next is we identified the city charter and the Comcast cable franchise. The city charter authorizes the city council to grant and regulate any lawful franchise. And the Comcast cable franchise has a local level playing field provision in it called competitive equity, and it's found in section 4.1D of the cable franchise. Section 9 of the cable officer report summarizes issues identified by the public in the public hearing and subsequent public comments. And we broke those comments down into a few categories. The first that probably received the most comment was a concern about economic redlining or cherry picking. There was comments that opposed the CenturyLink application because of those concerns that CenturyLink would pick and choose on which areas of the city to serve, and there were concerns about fair and equitable distribution of CenturyLink's product. Another group of citizens commented that they were in favor of the CenturyLink application regardless of the amount of the city that was built, and indicated that competition needs to be given the opportunity to gain a foothold before expanding. Another issue that was identified by the public was culturally diverse programming. There was 2 commenters that commented on the importance of that. The Communication Workers of America commented that the city would see greater investment in broadband services to homes and businesses, and CenturyLink would cause immediate job creation and a vision for continued job creation through growth, and those are identified in sections 9C and D. 9E identifies the issues that were raised by Comcast in their comments to the city. They identified 3 main concerns. First, a concern regarding whether and to what extent CenturyLink will agree to many of the franchise obligations that have been required of Comcast. Second, an expectation that the same level of due diligence and security and scrutiny that the city would apply and has applied to Comcast and its predecessors will also be applied to CenturyLink. And third, concern that CenturyLink's build-out commitment appears to stand in direct conflict with state law. We did note in our report that the SCC has ruled previously in the 621 order that that past processes used with the incumbent are not useful in reviewing new entrants. The process that the city is following, as we've outlined previously, is set forth in Minnesota Statutes 238.081, and that's the process that we're following. Section 10 of the Cable Officer's Report reviews CenturyLink's cable franchise application. And based on our review, we first looked at the city's compliance with its own application process and the state's application process. And to date, the city has followed that process substantially. Then we looked at CenturyLink's application and whether that substantially complied with the state application requirements. And we went through the requirements and identified where in the record CenturyLink complied with all of those requirements. And we found that there was substantial compliance with the state application requirements. Third, we reviewed whether there was substantial compliance with the city's competitive franchising policies and procedures. And like the state requirements, we went through and identified in the record where CenturyLink addressed the application requirements that are contained in the city's competitive franchising policies and procedures. We found that there was substantial compliance with those policies and procedures. Next, we also looked at at CenturyLink's financial, technical, and legal qualifications to operate in the city, and we found that it appears that CenturyLink does have the financial, legal, and technical qualifications to operate a cable system here in the city of Minneapolis. Lastly, we looked at the cable-related needs and interests. Those are largely identified in the current Comcast cable franchise, as well as a recent 2015 settlement agreement that the city reached with Comcast. Those documents, coupled with the public testimony, identifies the cable needs and interests of the city that we expect any cable franchise to address. Section 11 deals with future cable franchise considerations. So if the city council directs staff to negotiate a cable franchise with CenturyLink, we would expect that the following provisions would also be included in a cable franchise. This is not meant to be the exclusive list, but a list that we will for sure require in a cable franchise. The first is to address economic redlining or cherry picking to make sure that that does not happen in this city. As was explained at the public hearing, economic redlining or cherry picking is illegal, and we will have provisions that will prohibit economic redlining or cherry picking. Requiring diverse programming was an issue, as I mentioned, that was addressed by the public as a concern, and to the extent that we can require diverse programming, we will do that in the cable franchise. A reasonable build out of the city is expected that is fair and equitable and reasonable, and we expect to address any level playing field considerations, and finally compliance with the city charter and existing cable franchise with Comcast. Section 12 then has our recommendation, and our recommendation is to receive and file this report and to direct city staff to negotiate a cable franchise with CenturyLink. If the city does accept that recommendation to move forward, then the city would issue a notice of intent to award a cable franchise by ordinance. The franchise would be negotiated. A franchise would be then introduced. A franchise ordinance public hearing would be held, and then the city could act on that franchise ordinance 7 days after the public hearing on the ordinance. And with that, and I would really like to thank Matt Lively and Peter Ginder, especially Peter, for making himself available this last week. I really appreciate that, and I'm here to answer any questions.
Thank you very much, Mr. Bradley, for the comprehensive report, and thank you, Mr. Lively and Mr. Ginder, and Mike, of course, for being a part of this. First question I think we have here from Council Vice President Glidden.
Thank you, Mr. Chair, and I have a few questions. So what I think you answered for me, I just want to make sure I'm kind of crystal clear on kind of if we said go ahead and start negotiating, and I have some comments on that, but I was a little confused by the report on how this comes back to us, and I was also a little confused about the introduction of the ordinance, which seemed to why would we introduce the ordinance before we know if we're going to find some type of agreement that was acceptable? But what you're saying is the way that this would come back to us is we would then see the ordinance language, have a public hearing on that language, and then that would be how we would approve an agreement. It would be by approving the ordinance. So
Mr. Chair and Councilmember Glidden, correct.
Okay.
Absolutely
is there
correct.
a timeline on these negotiations if we
Mr.
did approve going forward?
Mr. Chair and Councilmember Glidden, there's no specific timeline.
Okay. All right. Okay. And then I was going back to section 3, and thank you for going through so carefully. I don't know that I had actually noticed that part of section 3 until you pointed it out that there had been a modification to the franchise for Time Warner, or at least that's implied. And so Maybe you can just talk about that a little bit. And what I'm taking from that is that should we negotiate and should we approve a franchise ordinance, there might be a procedure should something in that ordinance be not feasible, there would be a procedure for modifying.
Councilmember Quincy, Councilmember Glidden, yes, the cable franchise was modified in 1986, as I mentioned in my previous remarks and in the cable report. It wasn't Time Warner at the time; it was another predecessor in interest. But
excuse me,
I think Store, but I might be wrong about that too. And part of the reason that I put it in there is that it really shows how difficult it is to build out an entire cable system in a city, especially the city the size of the city of Minneapolis. And the incumbent had immediate shortfalls when it built the system, when it was the only cable operator in the city. And I think it also shows that when a competitor is coming in, just like the FCC found, it's very difficult financially for a competitor to build out an entire city rapidly. The incumbent no doubt had problems, and I think it shows that there are some challenges there for CenturyLink as they move forward.
okay. So, I mean, how I'm interpreting this report, I mean, just putting a little bit of my own thoughts in here, is this is sort of the last chance for CenturyLink to come forward with something that's acceptable. And I'll just put out there, if what CenturyLink's negotiated agreement looks like is the information that they have put forward today, I would not vote to approve that. I would not vote to approve that. So I can understand from the city's perspective, and thank you for your representation of us through these kind of uncharted waters for Minneapolis, since we haven't had a situation with proposed competition. So we're trying to wind our way through these issues of how to promote competition, but still comply with state law,
Correct,
as well as federal law, and bridge this issue of not being unfair as well to the current provider. I will say the one section of your report that I felt a little challenged by, just because I think it was softer than I had interpreted the language of the state law requirements and the federal requirements, is in section 10, where you have your review of the CenturyLink cable franchise application. And in that review, you state that CenturyLink has adequately explained why it omitted a time schedule for construction of the entire system and so on and so forth. And that's actually where I feel a little challenged by that part of the recommendation. And I do understand that's kind of juxtaposed with your recommendations for the elements that would be in a negotiated agreement if that was to come to pass. But as I read the application, I just don't see that there was any benchmarks proposed or any framework for build out. And we had no information about where the applicant is currently poised to serve residents in Minneapolis. So I found that challenging, other than their legal explanations about the difficulties, which I really take to heart, of trying to enter a market such as this and figure out how to make that financially feasible and move forward. But maybe you can explain that a little bit more, because I read that there had to be some parameters by the applicant, not no parameters. And that's what I'm seeing in their application.
right, Council Member, or Mr. Chair and Council Member Glidden. Yeah, we looked at that and looked at it hard, and you identified a challenge, no doubt. You know, the way we saw it at the end of the day was that, you know, CenturyLink feels that the build-out requirements are preempted by federal law. They've outlined that very clearly in between their application and their response to our request for information. So I'm looking at both of those documents, so Exhibit 2 and Exhibit 3, as far as, you know, what their position was. I think they listed out over a course of 3 pages their position on build out and whether or not that was preempted by federal law or not. So in our view, we were looking at, are the franchise requirements or are the application requirements addressed? And if they weren't addressed, why? And in our view, CenturyLink didn't specifically address that issue, just like you identified, but they explained why. And so for purposes of moving forward on the application, while their explanation may or may not be acceptable at this point, we think it is worth moving forward on a cable franchise negotiation basis to see if we can hammer out any differences on how the city is built out over time.
Well, I guess I'm looking at your statement of the SCC statement in Section 7, which describes that it is reasonable or would seem reasonable for a local franchising authority to consider benchmarks requiring the new entrant to increase its build out after a reasonable time, which again suggests that there must be some parameters in the application, not merely a statement that they feel legally challenged. And I will say, I don't know that anybody has successfully legally challenged Minnesota state law, so there's that too.
Right.
So anyway, that's why I just say I can't imagine a scenario where at least I would vote to approve a franchise agreement that included only the information that is presented today in the application. The other thing I wanted to ask you about is your recommendation that one of the terms in a franchise ordinance or agreement to be adequate protections to the public to prevent economic redlining or cherry picking. And I just wanted to address that for a second because this was another one of the areas of, I think, question for the applicant, because they had not to date even provided under seal, under confidentiality, in a non-public manner, their map of where they are today prepared to serve Minneapolis customers, nor, of course, had they yet explained anything about how they would have a plan. And again, I'm not talking about is the state law the right thing or not. Anyway, just, but what would be that plan, any plan, to build out the system? And I do not see, and maybe you can tell me if I'm wrong, anyway, that we would be able to adequately, at the city of Minneapolis, enforce any provision to prevent economic redlining or cherry picking unless we knew that information.
Mr. Chair and council member, that's exactly why we identified that as an issue. And we have to have the right benchmarks so that we can determine whether or not there's cherry picking or not going on in this city. I agree with you.
Well, you know, I will say I've had not a lot of comment on this. I know that I forwarded everything that I got to the public record, but just even today I got a couple calls in my office. And, you know, people want the competition, but they are concerned about the lack of information about how CenturyLink would go about providing this service. So I really want to put this out there. This is not about saying competition isn't valued. In fact, I just think we are in a really unique situation of opportunity here to have competition enter the market. I think competition is a good thing, but we can't accept competition without any parameters that allow us to say we are at least even attempting to comply with state law and federal requirements. So that's the way I'm looking at it, and I'll let others comment.
Are there other comments, questions? Not seeing any. Mr. Ginder, I wondered if you wanted to provide any insights that you might have on some of the questions that Council Vice President Glidden raised, as well as just commenting on where we're at in terms of a process for the city council under quasi-judicial information.
Mr. Chair, as you just noted, this is a quasi-judicial matter, and so we've had one public hearing, and staff has made a recommendation. So much like any recommendation, for example, from CPIN in a land use application, you may disagree with that recommendation. And for example, if you thought that the application was so lacking in important information, you could not accept staff's recommendation, find that they did not meet the necessary requirements under state law, and direct staff to make findings consistent with that. Our belief was that it was appropriate at this stage to go forward with it, in one sense to give CenturyLink a final opportunity to address all of the issues that have been raised here, which the Vice President has raised, which have been the primary issues from the beginning of the application process, and see where they end up at. Because if we move forward on this and we do a negotiation and there's an introduction, or notice of intent and introduction of a franchise ordinance, it will come back to you. You'll have an opportunity to then decide whether to grant or deny that application, and at that time, direct staff to make findings consistent with your final decision. So today is just a moment in the process, and the anticipation it will come forward. We would negotiate a franchise, and it may be possible we would come back to you with a recommendation that we not proceed any further, depending on what we reached. But we would anticipate coming back with at least proposed language, which you would then have a chance to weigh and exercise your quasi-judicial authority and either deny or grant that application.
Good. Thank you. Any other comments, questions? Councilmember Yang.
Thank you, Mr. Chair. Mr. Gender, I wanted to ask, at what point does the quasi-judicial proceedings end?
Through the chair, Councilor Yang, this is a little bit of a unique situation, but I would advise that you're in the middle of a quasi-judicial process, and so that to the extent, as you would in any quasi-judicial process, you would follow your standard rules. If we come back with a public hearing, that will be the second stage in the sense of the continuation of the quasi-judicial process, and then once it comes to your final decision, then you take your positions, make up your mind, and issue a decision.
One more, Mr. Chair. And Mr. Gender, another question with regards to this is that some of the issues laid out by Vice President Glidden with regards to, not knowing the map of service for CenturyLink and those sorts of things. I mean, are you suggesting that, maybe during the negotiation process, that might be clear for us, or that might be, disclosed at that point?
Through the chair, Councilor Yang, at some point in the process, we would anticipate some greater clarity in what would be happening as far as the build out, any economic redlining, any of that kind of the issues that have been raised by the Council Vice President.
Thank you. Not seeing any. Oh, okay. Councilmember Bender.
Thank you, Mr. Chair. I know we've had a decent amount of discussion about this, but I wondered if staff might provide more detail about how you think, a negotiated agreement would address these 5 bullet points that are this area of concern, where we would be asking for adequate protections to prevent cherry picking, the provision of culturally diverse programming, and so on. Could you give us more of a sense of, would we be adding in timelines potentially in our agreement? Would we be looking for specific measurable benchmarks? When might information become available about the geographic spread that we could compare with, our own demographics? Just to give us more of a sense of those details.
Mr. Chair and Councilmember Bender, I'm not able to give you all those specifics right now. I can tell you that in some instances, like the redlining concern, that is addressed in the Comcast franchise, and I would expect similar language in the CenturyLink franchise. But we need to have more discussions with CenturyLink to see how we're going to adequately address all of those concerns.
Thank you. Mr. Bradley, just while we're up there, just checking in on process again. Assuming we take the 3 actions today, which is to receive and file the cable officer's report, and directing staff to engage in negotiations, and then give notice of intent to introduce the cable franchise ordinance as the 3rd action. that would be the opportunity for the public hearing, and each of these would be attached with a recommendation from staff at this point, or at the conclusion. What I guess I'm saying is, we wouldn't be able to address all of these issues that have been outlined by the public and through the comment process, as well as the questions from the council members today, without engaging in negotiations to come back with a recommendation. Is that correct?
That's correct. A recommendation will come back, Mr. Chair, to you. As Mr. Ginder noted, there will be a public hearing, so there'll be an additional opportunity to receive more information, and you'll be able to identify to staff which recommendation you want to take moving forward.
Good. And so the 5 items that were noted in the report that you'd be pursuing in negotiations, outlined there in the executive summary on the second page, that would be all 5 of those items would be part of the recommendation and part of the franchise agreement that you'd
Correct.
bring
Yeah.
forward.
Yes, you would be recommending that staff move forward with negotiations consistent with what's outlined in the cable officer report.
Very good. Thank you very much. I think I'd like to move all 3 of those actions on the CenturyLink cable franchise application, and that is to receive and file the cabinet cable officer's report on CenturyLink cable franchising application. Item number 2, direct staff to engage in negotiations with CenturyLink regarding a cable franchise. And number 3, give notice of intent to introduce a cable franchise ordinance. I'd like to mention, of course, as that motion's been made officially, that there is not a timeline attached to this, but we'd like to see it as soon as staff is prepared to make a recommendation either direction. Any questions on that motion? Mr. Ginder?
And just for clarity, more for the public, Chair Quincy, is that the actual intent or notice of intent to introduce would come at a city council meeting once the city council adopts this report. So it's not coming today.
Thank you. Thank you for that clarification. Okay, all those in favor of this item, please say aye. Aye. And opposed? That item carries. Thank you very much. I think that concludes our business for the day. Is that correct, Ms. Armstrong? Great. We are adjourned.